This is where protections pursued have been protections denied. So here is a call to do it better this time because we see the connection, the voter suppression, rigged elections, or welcome to the colored section where 1965 and 2026 tell the same tale, one we all know well, how discrimination shows and a generation grows, but the timeline is frozen between Jim and his crows. I mean, we've seen it before. The deliberate manipulation, biased representation, but I guess somebody has to draw the line. Maybe this time unfair mapping won't be a part of the happenings and gerrymandering won't show its face. Oh, but let's face the facts. This is more than an act. It's a true reflection of the state we're in, where inequality masks as justice and fairness. So this is removing every blockade and barrier. It's overcoming obstacles to relieve every plight. Oh, this isn't just about voting. This is a right to life.
All right, good evening, everyone. Thank you again for joining us. And as the video said, this isn't just about voting, right? This is about the fundamental rights of citizenship and representation in every community here in Louisiana. My name is Max Martin. I'm the Research and Impact Director with the Power Coalition. And we are so excited this Wednesday to host our Power Day at the Capitol, where we will be bringing folks from all over the state and talking about the Voting Rights Act. We are extremely excited. We're going to have a huge crowd, and we're so glad that you're going to be a part of it. And thank you again for coming tonight to learn more about the State Voting Rights Act and to prepare and get ready to make Wednesday as successful as we all know it can be. So, without further ado, I'm going to throw it over to our partners at the Legal Defense Fund to help walk you through some more details on the VRA itself, as well as how you can be most powerful this Wednesday when we go to the Capitol. So, thanks for being here, and let's kick it off.
Hi, everyone. Thank you, Max. My name is Tori Wenger. I'm an attorney at the Legal Defense Fund. I'm probably going to be off screen for most of this, so my internet connection doesn't mean that you can't see the slides, but I am very happy to be joined with my colleague Amani Brooks from our policy team. We are going to be tag teaming on tonight's training. Amani, if you quickly want to say hi, I'll get into the rest of the agenda.
Hi everyone, my name is Imani Brooks. I'm policy counsel at the Legal Defense Fund and I work on state voting rights acts across the country. I'm very excited to be working here tonight on the Louisiana Voting Rights Act.
Excellent. Thanks, Amani. So just to overview a few of our goals for this evening, we know that more time is held, but we're hoping to keep this training to an hour, and we will very much be available during this call or in the future for any questions that you might have. Amani and I travel. Will will be in on the ground on Wednesday for the day of action at the Capitol, and otherwise are very privileged to work with Max and the rest of the Power Coalition team on all things advocacy around voting rights, and especially this push for a state voting rights act in Louisiana. So first, we're going to ground ourselves in a bit of the history that's most important to the context of pushing the Federal Voting Rights Act, now the state analogous acts, and especially this movement in Louisiana. We're also going to give you more overview on all of the incredible research, the cross-state, cross-nation push for state voting rights acts, the popularity of this policy, and so many of the different components that are included within it, including in Louisiana's own version, which has been filed now. We'll give you the tools that you need to understand what exactly the Louisiana Voting Rights Act is, and then finally, opportunities to prepare testimony, best practices for making sure that your voice is heard and is part of the record for why we need these types of protections across the state of Louisiana. So before we get into the specifics of the Louisiana Voting Rights Act, it's important to understand the history that it builds off of when it comes to the historic push for the Federal Voting Rights Act of 1965. This act was enacted, of course, to protect the right for all of Americans to vote, but especially to address rampant voter discrimination against Black voters and other communities of color that truly kept our nation from achieving its promise of being a multiracial, inclusive democracy. And in many ways, we describe the passage of the Voting Rights Act as the birth certificate of American democracy and a true pivot point in achieving that promise. The federal VRA is largely known as one of the most effective pieces of civil rights legislation ever to be enacted in our nation. It prohibits discriminatory voting laws and practices and provides tools for voters to challenge discrimination in court. Up until the Shelby County ruling in 2013, which we'll discuss more, it also required jurisdictions with the worst histories of voter suppression to obtain pre-clearance, which is a fancy word for pre-approval from the federal government before they could enact those changes. So there was these types of checks and balances and federal oversight for jurisdictions, most predominantly in the South, but others across the nation as well, with these bad track records to make sure that whether it was discriminatory maps or discriminatory policies or administrative decisions, they couldn't go into effect and have the impact of voters losing their vote. Instead, there was a checkpoint before that, before they became law or in effect. It also, the federal VRA also had a bunch of other important dimensions like a protections around voter access, requiring bilingual election materials in certain jurisdictions where population thresholds were met, providing protection for voters with disabilities to receive assistance from the people of their choice, further protections against voter intimidation. It's an act that had multiple different sections. But unfortunately, in the decades since it was enacted, there's been a variety of different efforts to erode these key protections, often through lawsuits that have challenged certain provisions or other ways in which the federal government or state actors have tried to get in the way of voting rights. As I mentioned, Shelby County v. Holder was a real kind of pivot point in the legacy of the Voting Rights Act and how effective it was or has since then not been able to be when it comes to some of its proactive provisions. In Shelby County, the Supreme Court essentially said that the method that was used under the VRA, Section 4B specifically, to determine which jurisdictions needed to get that pre-approval from the federal government before enacting voting provisions, that was outdated. So while the concept of pre-clearance could live on, the application of it has essentially been void. And since that decision, Congress has not yet acted to come up with a modern alternative to that former process for determining the applicable jurisdictions that the court had determined to be outdated. In Brnovich versus DNC, a more recent decision out of 2021, the Supreme Court made it a lot harder to prove discriminatory voter suppression or these claims that we call vote denial. Things like challenging changes to polling sites, things like challenging voter identification requirements. The standards for review under Section 2 of the Voting Rights Act about those types of quote unquote vote denial or voter suppression claims became much more challenging. Again, the court did not completely overrule the application of the law to those types of practices, but it made the burdens on plaintiffs, on civil rights attorneys, much more difficult to prove. Meanwhile, we've also seen the Supreme Court and other federal courts in other ways try to make VRA application more complex, costly, difficult. You also have to navigate the federal court system, which can impose a variety of other burdens for litigants as opposed to their state courts. And we've seen other more novel claims start to hit some of the federal circuits, not necessarily applicable yet to the Fifth Circuit, but in other circuits like the Eighth, we've seen efforts to try to essentially say that only the federal government can bring these claims and private litigants are barred from having a private right of action under the Voting Rights Act, especially Section 2, which is a ruling that's recently came out of the Eighth Circuit Court of Appeals impacting states like Arkansas, for example. So why does this all matter in Louisiana? For a multitude of reasons. First of all, Black voters live in Louisiana, and the Legal Defense Fund has worked for over 80 years now to ensure that the rights of Black Americans and all people are protected. And that's why we worked so hard to get the VRA passed in the first place. And up until 2013 in Louisiana, had the help and the proactive protection of the federal government trying to ensure that discriminatory maps or discriminatory voting policies could not go into effect. Louisiana's track record of voter discrimination and especially racism against Black voters was so robust that it was one of only 9 jurisdictions that, up until that 2013 ruling, was covered in its entirety by the preclearance coverage formula of the Voting Rights Act. And today, if you all have been following along the fight for fair maps and our collective work with Power Coalition and other partners for many years now, you'll know that Louisiana is at the center of the, most pressing, pending challenge regarding how redistricting can interact with racial justice remedies and whether or not the Voting Rights Act will still be able to be a tool for Black voters like our plaintiffs and litigants that you see here, including Ashley representing Power Coalition, whether or not Section 2, a prohibition on vote dilution or the drawing of maps to try to undermine the voting strength of minority populations like Black voters in Louisiana, whether or not that can stick, whether or not we have these VRA protections in redistricting. So, as you can see, for decades and decades, as powerful and robust as the Voting Rights Act was, as important as it was as an achievement, that's part of why it has been under attack and chipped away in the federal courts, why we need other alternatives in the states to be able to fill the void left through this erosion of the VRA at the federal level. Importantly, we are seeing contemporary attacks. When we talk about Voting Rights Act, we can't just keep it to a silo of the distant past. We have to understand how voter suppression tactics and vote dilution have evolved over time in response to mobilization and organizing of Black communities. As sophisticated and good as organizers have been at trying to defy the odds and make sure that everyone has equal access to the ballot, so too have the forms of suppression evolved and become sophisticated over time. So we are seeing attacks on voting rights now. Unfortunately, it's a key week for federal legislation aiming to erode protections at that level. We're also seeing a lack of action to restore protections. So while we see very dangerous bills like the SAVE Act advancing through Congress, we've seen inaction on things like the John Lewis Voting Rights Advancement Act, which would restore protections. So, in the face of all of this, voters have less protections than they did over 65 years ago when the VRA was passed in many ways, and continue to face barriers such as unfairly drawn districts, inaccessible polling locations, outright voter intimidation, long lines, stringent voter ID requirements, or efforts to make them even more stringent. And other issues that we see, and every example you see on the screen right here is straight from the state of Louisiana itself. So that's where I'll ship it over to Amani to talk about State Voting Rights Act as a response to everything that we're seeing.
Thanks, Tori, for that setting the stage on the with the federal context. So now we're going to talk about how to respond to those different things. Generally, a growing number of states are acting to protect the right to vote and safeguard our democracy by passing or introducing state voting rights acts. State VRAs provide protections that are essential for voters to fairly participate in our democracy. And they do this by filling in the gaps that federal law has left and also thinking about what are some streamlined voting rights protections that each state might need given their history. Next slide. So on this map, you can see really what the momentum looks like. We have states in yellow where a state VRA has been introduced, including Louisiana and many states across the South. And then we have in dark blue where a state VRA has been introduced and had some movement passed out of one chamber or one committee. And then the light blue is where state VRAs have been enacted. So right now there are 8 states with enacted voting rights acts. And we've had a Voting Rights Act enacted every year since 2018, except for the pandemic year of 2020. Next slide. The state VRAs aren't just good policy, they are popular policy. Next slide. We have at LDF, we did a little bit of research and polling in 2024 and found that more than three-quarters of voters support passing a Voting Rights Act in their state, with over 60% strongly supporting a state Voting Rights Act. Next slide. And this support transcends partisanship and demographics. You see it across race, parties, gender, ages, and that just really shows how strong the support for a state VRA is. And then this last slide shows that 3 in 4 voters across this country want their representative to prioritize passing a state VRA, which speaks to how state VRAs are seen as a very important measure and something to push to the forefront amidst other voting rights bills. Next slide. So let's talk about what is in the Louisiana Voting Rights Act, or SB 365. Next slide. So this is a part of the SB 365 that really is the kind of legislative priorities or history showing that the legislature is taking this seriously. The right to vote is essential, recognizing that there has been past and present forms of discrimination in Louisiana, and that our democracy is built upon the right to vote and the freedom to vote. Next slide. So here we have our wonderful sponsor, Royce Duplessis. And these are the elements of the Louisiana VRA. So there will be protections against vote dilution, protections against voter suppression, a pre-clearance program, and a private right of action. And if you have, oh, sorry, back to the last slide. Okay. This is a very specific targeted provisions for Louisiana. Every state has a different combination of provisions in their state VRA, but these are the ones for Louisiana. Next slide. So the prohibition on vote dilution. Louisiana is familiar with vote dilution given the Calais case, and this bill would allow for protection at the state level against vote dilution. So this is vote dilution could be unfair districting maps or election systems that weaken or drown out people's voices based on their race. And our prohibition in the Louisiana VRA is learning from federal litigation and making the legal standard more efficient and streamlined so that litigation is more predictable, less time intensive, and less costly than vote dilution that we've seen under the federal VRA in Section 2. Next slide. So this video is going to go a little bit more into detail.
Racial vote dilution is a phenomenon that occurs when an election system works in such a way as to systematically weight the votes of a particular racial or language minority group less than other members of the electorate.
There are two main examples of vote dilution.
For example, you might have an at-large election system, right? Which is to say that the entire system votes for every single member of the city council or the school board.
Imagine a city that elects 5 members to the local city council. They're all elected by the entire electorate. So in an electorate that's maybe 60% white, 40% black, and there's racially polarized voting.
Racially polarized voting occurs when racial groups consistently prefer different candidates, and the preferred candidates of one group are usually defeated by the preferred candidates of the other group.
And so they're never going to be able to overcome the white people who are 60% of the population always voting for their preferred candidate. You would have a scenario in which white voters would control all 5 of the at-large seats.
Another example of vote dilution is unfair districts that are drawn in a way that does not fairly represent voters.
There are 2 ways to draw unfair districts. One is called cracking, the other is called packing. And this example is that the districts have been drawn unfairly, sort of continue that locking out of black voters from the electoral process.
Vote dilution is a problem. It can have real negative impacts on your life.
If you have a system in which 40% of the population is totally unrepresented in government, and it becomes very easy for you to ignore the interests of that 40% population. The white side of town has roads, indoor plumbing, good schools, and instead, the black side of town, in which there's no representation on a county commission, has outdoor plumbing, has septic tanks, has no roads, schools are underfunded.
People are getting the majority of their government services from local governments. And so making sure that local governments are actually structured in a way that racial minority groups, language minority groups, as well as majority groups can have an equal say in government, it's just so critical.
Although we have a federal Voting Rights Act, it has been watered down. It is no longer enough, and we need more to address vote dilution.
We've seen real difficulties for voters of color in bringing claims to vindicate their rights. And we've seen the U.S. Supreme Court consistently dial back what Congress intended to circumscribe those protections for minority voters.
Despite these problems, state voting rights acts can be a solution.
State voting rights acts or make it easier for minority voters to prove racial vote dilution, or just make it easier for voters to vote by adopting systems like eliminate at-large elections and replace it with a district-based voting. If you decide to break up that city council so that all five of them were voted in by district, that would mean that you would much more likely to see black voters having 2 or 3 of the seats, so that black voters would actually have a closer proportionate number of representatives on that city council.
State voting rights acts also recognize that a variety of remedies, not just single member district systems, may be the right approach in a particular jurisdiction. So things like ranked choice voting, they may be more appropriate in a given jurisdiction, more cost effective, more efficient to address and remedy racial vote dilution than a redistricting plan.
State voting rights acts are beneficial for both voters and jurisdictions.
There are a lot of different benefits to state voting rights acts. They can make proving the claim easier. They can open up the different types of remedies that states can adopt. They can also include notice requirements. So that gives the local jurisdiction the opportunity to work with minorities in their community to either create districts or systems of election that are actually fair to everyone without having to spend the time and money and resources that go along with litigation.
State VRAs also make really plain certain good things. One of these is coalition claims.
A coalition claim is a claim in which you're arguing that a minority group or different minority groups can join together and bring a claim under the Voting Rights Act or another similar Civil Rights Act.
Because you may not have enough Black voters to form a single member district, and you may not have enough Latino voters to bring a single member district where Latino voters are majority, that it's impossible to draw them into their own districts, that you need to be able to draw a coalition claim so that you can have a Black plus Latino majority district or districts plural.
Even as we work to strengthen and restore the Federal Voting Rights Act to its full power, state voting rights acts can play a real complement to that. And so it's really important that our states continue to be the laboratories of our democracy and to do so in a way that is productive and moves civil rights forward.
Thank you for watching LDF and CAP's State Voting Rights Act video explainer series. This video discussed vote dilution, and our experts explained how state voting rights acts can help address this harmful policy.
To learn more about the essential components of state voting rights acts and how they can help us build an inclusive, multiracial democracy, check out our website and follow along with this video explainer series.
Okay, great. So I will put the link to the video explainer in the chat eventually, and you'll see a couple more as we go along. But they are great resources to learn the kind of technical terms that we're going over. So the other element of the Louisiana Voting Rights Act is a prohibition on vote denial or vote suppression. And so this is really important because at the federal level, Tori mentioned the Brnovich case, we really don't have a good test anymore to bring vote denial claims under Section 2. The test is very convoluted and burdensome and really does not center the lived experiences of Black voters, of the discrimination that we have faced over the years. And so state VRAs are bringing in a state level prohibition on voter suppression to make sure that no matter what happens at the federal level, there is protection. And so a Louisiana Voting Rights Act can be used to challenge practices that create barriers to voters of color, and that can include things like inaccessible or insufficient polling locations, specifically in communities of color, wrongful voter purges that disproportionately harm voters of color, holding of elections on unusual off-cycle dates that disproportionately suppress turnout among voters of color, and improper election administration decisions or equipment allocations that lead to longer lines in communities of color. Next slide.
So voter suppression is really any activity, legal, extra legal, otherwise, that's aimed at stopping people from exercising their right to vote. Really, as long as we've had voting in the U.S., we've had voter suppression.
The first turning point in the effort to stop voter suppression really came in 1870 with the adoption of the 15th Amendment after the Civil War. Unfortunately, even though that had been adopted in the nation's highest law, the Constitution, we continued to see voter suppression. So there were legal efforts, things like a grandfather clause, which said if your grandfather could vote before the Civil War, then you are allowed to vote, clearly intended to disenfranchise Black people, many of whom had had enslaved ancestors. And then there were indirect things like poll taxes and literacy tests. John Lewis famously talks about people being asked, how many bubbles are there in a bar of soap, right? Something that has no answer. Some modern examples of voter suppression include things like cutting the number of polling places, cutting down the number of days where you can do early voting, enacting a strict photo ID law, also purging voter rolls, right, before you get to an election.
There was a necessity for a federal Voting Rights Act to come behind what was already constitutionally protected because we weren't doing a great job. The Federal Voting Rights Act is designed to protect your access to the ballot box and to make sure that you're not being discriminated against based on your race or other categories. And it had really strong protections against voter suppression.
The Voting Rights Act of 1965 brought the 15th Amendment back into the law books. And in 1982, Congress made it clear that suppressing the vote, even if you didn't intend to, but the actual effect of the practice was to suppress the vote, that was not okay under the Federal Voting Rights Act. Unfortunately, in the last sort of 15 years, we have seen that rolled back.
In the Shelby County decision, the Supreme Court gutted a portion of the Voting Rights Act. And what you saw after that disastrous decision was the floodgates open, really. Lots of states put really restrictive and sometimes really racist voting restrictions on the books in order to stop people from getting access to the polls. And recently, there have been other federal court decisions that make it harder for individuals whose voting rights have been violated to fight back.
In 2021, we had the first case that the Supreme Court took on this question of what is the standard for voter suppression under Section 2 of the Voting Rights Act. Section 2 being the section that applies to the entire country. And in that, they basically made it harder to prove. We know that federal courts have grown increasingly hostile to voting rights, and so being able to go into state court is really important now more than ever. State voting rights acts are able to get at practices that federal laws just don't get at. For example, something like in Virginia, where they prohibit voting practices that result in the denial or abridgment of the right of any citizen to vote on the basis of race or color. But you can also add in specific extra things, like moving a polling place within 20 days of an election. The language in state VRAs can not only go beyond the federal VRA as it currently is, but it can even go beyond the federal VRA as it was in 1965.
State voting rights acts provide more tools to help protect voters from voter suppression, including private right of action, allowing individuals and organizations to go to court to have folks' voting rights protected.
So if you start enacting laws that mean that some people can't register and some people can't vote, particularly if those people are historically disenfranchised minorities,
That means you end up with only one group of people, or predominantly one group of people, deciding who gets to make decisions. So it is really important that we stop voter suppression so we can keep our democracy, of, by, and for the people. And if we are going to do that, we need laws. We need to be able to go into court and say when a particular practice or a particular law is disenfranchising historically marginalized communities. And state voting rights acts are a way that we can do that.
Thanks for watching LDF and CAP's State Voting Rights Acts video explainer series. This video looked into the concept of voter suppression, and our experts discussed how state voting rights acts can address these harmful policies.
To learn more about the essential components of state voting rights acts and how they can help us build an inclusive, multiracial democracy, check out our website and follow along with this video explainer series.
So I want to just underscore one thing on the voter suppression thing. Provision is that it is giving a private right of action to bring those claims, and that's very important right now. Because not only is the legal test for voter suppression very convoluted, there has been some bad precedent in federal circuit courts around whether or not you can bring a case as an individual or as an organization under the Voting Rights Act. And so we're keeping that in mind, right, when we're thinking about what does a state Voting Rights Act look like. It is to address some of these harms and this bad precedent and make sure that we can really actually go out and find relief for the harmful policies. Okay, so the third element of the Louisiana Voting Rights Act is a state level pre-clearance. And so, as we mentioned earlier, in Shelby, we lost federal pre-clearance, and a state voting rights act is going to restore and modernize that pre-clearance framework as inspired by the Federal Voting Rights Act. It's going to require local governments with histories of discrimination to prove that voting changes won't result in discrimination before they can be implemented. So the Louisiana Voting Rights Act allows for lawsuits when there is a harm identified, and then also to stop the harm from ever happening through pre-clearance. And pre-clearance, another element of it is providing a streamlined administrative process with expert review of key voting changes. Next slide. So how does it work? So one element of the program is that local governments at high risk for voting discrimination are opted into the program. And this occurs through a coverage framework. So we're thinking about places that historically discriminated against protected classes and looking at things like arrest rates, looking at education rates, looking at housing segregation, etc., to make these determinations. And then these places under the coverage framework, they must get voting changes pre-approved or pre-cleared by a commission housed within the Office of the Inspector General. And so the idea with this Voting Rights Commission is to create an independent expert review commission to handle this process and to make sure that it will be taken seriously and followed through. And the program can require preclearance of all voting changes, like removing people from voter rolls or moving polling locations. Next slide.
Although the 15th Amendment to the Constitution prohibited the denial of the right to vote based on race, Black voters faced barriers to voting immediately.
One example is, for a long time, the way that jurisdictions prevented Black people from voting is by preventing them from being able to register in the first place. And after that, a new form of discrimination evolved. Election systems that effectively made the votes that they cast meaningless compared to white voters through gerrymandered districts. And so that's just one way in which every time Black voters or voters of color find a way to participate in the political process, they're met with new forms of discrimination.
Federal Voting Rights Act was really designed, preclearance in mind in particular, to prevent that from occurring. It's a policy that required jurisdictions with a history of discrimination to submit any changes to their voting policies or election methods to a federal court or to the Department of Justice to be reviewed for whether they discriminate against people of color based on race.
There are a lot of benefits of a preclearance program. Most importantly, preclearance was one of the most effective laws in our nation's history. It protected millions upon millions of voters against racial discrimination in voting. There were actually over 1,000 proposed changes that were blocked by the preclearance program, and this was all because the preclearance program under the Federal Voting Rights Act provided the robust protections that voters of color need and deserve to prevent racial discrimination in voting from taking effect in the first place.
You can actually see the tremendously successful effect that preclearance had by looking at what happened after the Supreme Court effectively gutted the program.
In 2013, the Supreme Court decided that the way that jurisdictions were determined to be covered by federal preclearance was unconstitutional. As a result, it effectively gutted the preclearance provision of the Voting Rights Act.
This was a truly devastating opinion. Justice Ruth Bader Ginsburg, in her dissent in the Shelby County opinion, famously said that getting rid of preclearance was like throwing out your umbrella in the middle of a rainstorm because you're not getting wet. And her words proved, unfortunately, to be all too true. We saw the return of significant discriminatory voting policies and practices that preclearance had kept at bay for decades upon decades.
There's a common misconception that the Shelby County decision struck down preclearance itself, but it didn't. It actually just struck down the coverage formula that underlies preclearance, making it effectively inoperable. That means that states and the federal government, in fact, are permitted to enact preclearance programs.
New York and Connecticut have passed State Voting Rights Act laws that include preclearance programs, and other localities are considering doing the same.
Through state-level preclearance programs, localities like counties and towns that are at a high risk for voting discrimination submit key voting changes to a state authority for review before these changes can go into effect. The reviewer could be a state agency like the Attorney General or Secretary of State, a court, or another body with relevant expertise. They provide an expert set of eyes to make sure proposed voting changes don't discriminate based on race.
So a state preclearance program could work like this. Let's say a town was considering moving a polling place from a Black neighborhood across town, but doing so would require the Black voters to travel long distances to get to another polling place, or would require them to wait in long lines in the remaining locations near them. That proposed change would likely be struck down by the reviewing body, and the town would have to either appeal that decision or come up with a new plan for the location change that would serve all voters fairly.
There's a framework to identify jurisdictions within the state. For instance, most states cover jurisdictions that have committed a violation involving the right to vote. In some states, jurisdictions can be covered by severe racial disparities in political participation. You see severe racial disparities in voter turnout, that's a sign that something's happening in that jurisdiction that's problematic, and voting changes should get a close look before they can go into effect.
Preclearance is not a punishment for local jurisdictions. They get a ton of benefits out of having really an extra pair of eyes at the state level to assess, to analyze their voting policies and determine whether they have a discriminatory effect. Oftentimes, local governments really don't have the resources to be doing a constant evaluation of every voting policy that they're considering for racial impact. But the state has those resources, and preclearance really allows the state to marshal those resources where they're needed.
You know the old expression, an ounce of prevention is worth a pound of cure. And that's why preclearance is so important, because it prevents changes from going into effect and prevents the need for prolonged and costly litigation to address those problems. The federal VRA has long been seen as the most significant civil rights achievement in our nation's history. I believe that a state VRA can be the most significant civil rights achievement that any state legislature could accomplish for voters in their state. State VRAs provide sweeping and robust protections for the right to vote. And there is such interest in state VRAs right now at this critical moment. Many well-intentioned leaders at the state level are interested in finding robust protections against racial discrimination in voting.
Thanks for watching LDF and CAP's State Voting Rights Act's Video Explainer series. In this video, our experts discussed how state voting rights acts can address harmful policies by adopting pre-clearance provisions.
To learn more about the essential components of state voting rights acts and how they can help us build an inclusive, multiracial democracy, check out our website and follow along with this video explainer series.
Alrighty, so the last element of the Louisiana Voting Rights Act deals with enforcement. So we're giving in the act the prohibitions, the protections, and now this is explaining how we can enforce them. So as I mentioned earlier, a very important aspect of the Louisiana VRA is that you can bring a lawsuit. There's a private right of action, and specifically a state attorney general, organizations, and/or affected private individuals can bring lawsuits. There's also an element where there's a notice letter process, which means that the jurisdictions are given a little bit of a heads up. Hey, we see this issue happening. Do you want to resolve it without litigation? And there's a process for that, a timeline to allow that. And that incentivizes, collaboration, it incentivizes centering the voter's experience and also avoiding litigation. And then preliminary relief remedies that are more expansive than the federal VRA and also might be more appropriate for the actual situation and not just kind of trying to make a one size fits all. And then other specific procedures. Um, all of these are all the enforcement mechanisms in a VRA is thinking about how can we get the best relief at the most efficient way. And so ideally, money and time will be saved for all parties once the Louisiana VRA is passed. And I will turn it back over to Tori to talk about, all right, now we know what a VRA is. How are we going to make some noise about it?
Great. Thank you so much, Amani. All right, so we are going to go through a bunch of very technical ways that you can make sure that your voice is heard, that you are part of this movement in a very tangible way to make sure that Louisiana takes these urgent steps to protect the right to vote. So we are going to obviously have the lobby day on Wednesday, a huge moment for Louisianians, supporters across the state and beyond to be able to come together collectively at the state capitol. And we also know that that is not going to be the exact day that the bill is heard. So it's important that we build on the momentum of Wednesday and that huge showing of unity to also make sure that the drumbeat and your voices get into the record beyond that day and on the date of the hearing when SB 365 will actually be heard. So one way you can do that is through written testimony. And there are a variety of ways to make sure that you're either signing on to letters like the one that Power Coalition has posted and created along with LDF, or by preferably also submitting your own story, your own narrative, what motivates you to join this effort to pass the Louisiana Voting Rights Act. You can submit written testimony to the Committee on Senate and Governmental Affairs. That is the first committee that will hear this bill. They generally are meeting on Wednesdays. We will be watching their agendas closely to see when SB 365 is added to them. And then you'll have the opportunity to review the agenda, see what else is on that day, but submit your comment, your own individual narrative for why the Voting Rights Act is important to the committee directly. I've got the email address here. Power Coalition always has really helpful take action links on their website as well. The QR code will direct you there. But comments in writing to the committee are generally due at least 4 hours before the committee meets, or if you have some type of visual presentation, that would be 24 hours in advance. Typically, that's if you plan to both submit something visually ahead of time and then also speak in person during the committee meeting. But in addition to sending in your own written testimony to the Senate on the Senate Committee on Governmental Affairs, if it crosses over to the House, also to the analogous House Committee on House and Governmental Affairs, you can also, in addition to that, send your own story, your own personal appeal to your lawmaker. So, your representative on the House side, your senator, you can find their individual contact information to reach out to their offices at the link here, tinyurl.com/LA Leger contact. So whether or not you are submitting things to Senate and Gov, which I would highly encourage you to, or also reaching out to your own lawmakers, the important part is making sure that your voice, your story, your own personalized rationale for why a state voting rights act is so important gets before these lawmakers as they're making critical decisions about what to do with this bill. So ultimately, your words are going to be way more compelling coming from you than any type of Mad Lib, sign-on letter, etc. But we want to make sure that you're comfortable with how these things are framed, some of the formalities, etc. Typically, you will direct your letter or your email to the chairman of the committee and members of the relevant committee here. Generally, it'll be the Senate and Governmental Affairs Committee. Introduce yourself, say where you're from, make it personal to your parish or your city, and indicate clearly your support for the bill, listing out the bill number. You could also include the act name here. SB 365 has an actual name. It is called the Louisiana Voting Rights Act, sponsored by Senator Duplessis, and more lawmakers are signing on as well. And then you can explain why you support it. What are those values that really resonate with you through all the things that you just learned? What are the practical components that you find important? Do you have a personal story where your community has faced barriers to equal participation, where you have tried to go vote at the polling site you always went to for years and then suddenly it's across town? Or you've had other issues where you or someone you love have faced challenges in registering to vote, in exercising their right to vote, in feeling like their voice is truly being heard, or that the maps that are enacted, the lawmakers who are being sent to Congress or sent to the state legislature and otherwise are truly reflecting your community's needs. If you have a narrative that you think ties back to the principles of a state voting rights act or the broader picture and narrative around the push nationwide in Louisiana for voting rights, that's where your voice is so uniquely helpful because no one can tell your story or your perspective on the importance of this bill like you can. So, in addition to submitting your own personal statement, you can also sign on to the coalition letter that Power Coalition and LDF have already generated. Many of you probably already have. A thank you for that. It is calling on all lawmakers in Louisiana to co-sponsor the Louisiana Voting Rights Act, to then vote for it, vote for SB 365, and to stand with the people on March 18th for this day of action at the Capitol. When you get to the Capitol, whether it's for committee meetings this week where other bills will be heard, many on voting rights, and you might have an opportunity or desire to speak up then, either for or against different bills. But if you're able to get back to the Capitol for the date of the actual hearing, we're anticipating it might be around early April, but we will stay tuned to see those agendas produced. Once you get to the committee room, what you'll do is when supporting a bill like SB 365, you'll fill out a card like this green one you see right here, and then you would be called to the table like you see our friendly folks and collaborators here doing as well. It's a Senate committee hearing from back during our redistricting fight. The card you fill out here is pretty straightforward. You're going to indicate which committee, fill out the number of the bill that you're interested in. So here it'd be SB number 365. Then you get to check one of the following options. I'm present and would like to speak. I'm present and will provide information if requested. Or although I do not wish to speak, I'm present and in support. So committee members will often tally up how many people are speaking up in support of a bill. And if I'd actually speak on the record, you can just check that third box. But if you are willing and able, and we can boost your confidence enough too, I'd really encourage you to try to share a few words because I promise it is incredibly rewarding and you don't know how valuable it is. So you'll also be asked to fill out identifying information, so be cognizant of that, and then sign and witness it. So oral testimony, I know can be a little bit intimidating or overwhelming, but ultimately all you're really doing is sharing your story. We are not expecting you to be a legal expert on the SVRA in Louisiana, though you just did this training and now know so much more, and will have the advantage of those videos and other materials that we'll be bringing to share. But at the end of the day, whether or not you are an expert on all the in and outs of this bill or model legislation across the nation, you are an expert on your own story. You're an expert on your values and how they relate to this push for a fair and open democracy and equal protections for all Louisiana voters, especially those who have and continue to face the most extreme forms of voter suppression. When you provide your oral testimony, again, it's similar formalities and nothing too complicated. You're just going to address the chair and the members of the committee, thanking them for the opportunity to speak, and then introducing yourself, your name, where you're from, and if you have a particular organizational affiliation or group that you're there to represent or you're there with. You don't have to. You can speak on behalf of yourself, no matter who you are. You're able to just share your views and why this legislation speaks to you. Depending on how many folks are in the room, how long the meeting is going, sometimes they will invoke a 3-minute limit on comments. And just generally speaking, it's good to have statements prepared or outlined that are going to be that concise while still hitting the main points that you want to drive home. And ultimately, tell your story in your own words. We will go through talking points that we've workshopped and that speak to why this legislation is so important. But again, your own narratives, your own why for the Louisiana Voting Rights Act is going to be most compelling and the highest contribution that you can make because you're the only one that can do it. Remember that these stories, these written materials, they are going to be part of a public record, and that could end up in court documents. It will end up in the legislative record and history behind this effort. It could end up in press coverage. All of that is at the end of the day really exciting when it means that it's building momentum for a worthy cause. But just be conscientious of that in terms of what you're sharing, how you're framing things in your own personal comfort levels. So let's go through some talking points. Again, with the headline of the things you share about your own views and experiences, the values that compel you and you think should speak to your lawmakers on a real kind of personalized and compelling level. Those narratives, those values are going to be what resonate most. The type of storytelling that can move audiences and speak across party lines or other difference is poignant, is going to be most effective here. But we want you to also have the structure and kind of the backup of some pre-vetted talking points that guide us through why this legislation is so important, why it's resonated with so many voters nationwide and in Louisiana. So again, this is going to map onto a lot of what we've already discussed tonight and what you can kind of re-review in the materials that we share or those explainer videos that we also previewed. So one thing to kind of lead us off is the fact that this is a new chapter in a long fight that has started with the push for the Voting Rights Act of 1965 as that beacon of the starting point for a true multiracial, fair democracy that we are trying to maintain and expand. But today we know that federal attacks on voting rights increase every single day, and our democracy is facing existential crisis. We are truly at a pivot point, despite the fact that 60 years ago, more than 60 years now, the passage of the VRA fundamentally reshaped democracy and was truly the birth certificate of America's multiracial democracy, marking the end of the Jim Crow era officially by dismantling many systematic barriers to Black political participation and representation. The VRA did that by giving Black voters and other historically disenfranchised groups a tool to challenge discriminatory laws in court, and its impact was immediate and transformative. For decades, we saw how the VRA's core protections were considered settled and essential. And in fact, Congress reauthorized the VRA 5 times with overwhelming bipartisan support, reaffirming a shared commitment to fair and equal access to the ballot. However, we know that today the VRA has become a shredded shield in many ways. We've discussed this throughout the call. In recent years, we saw the Supreme Court rulings in Shelby County v. Holder and Brnovich v. DNC erode essential VRA protections. Alongside rampant restrictive voting policies, Supreme Court challenges now, like Louisiana v. Calais, aim to curb our rights even further. The consequences of these decisions ultimately disproportionately impact Black voters and other communities of color, as well as voters in rural areas, first-time voters, limited English speaker voters, and more. State VRAs are the counterpoint to that. State VRAs offer states an opportunity to go above and beyond federal protections. They don't just restore safeguards that federal courts have limited, but they allow states to be laboratories of democracy. As Amani so importantly highlighted, SVRAs are really popular. 78% of voters across the country support their state legislature passing a state VRA. State VRAs have gained traction in recent years across the nation, from coast to coast, representing every single time zone in the continental US. We've seen a VRA passed and many more introduced, or having components of the legislation enacted in recent years. States in the South have been no exception. Virginia passed a State Voting Rights Act in 2021, and other southern states have introduced similar legislation in recent years, including Alabama, Florida, Georgia, Mississippi, Texas, and now, of course, Louisiana. Louisiana urgently needs protections for voters who have been historically discriminated against at the polls, and the Louisiana VRA provides exactly those protections. We know that Louisiana has suffered a long and sordid history of voter discrimination. And in a state with the second largest Black population in the nation, 1 in 3 voters in the state of Louisiana are Black. We also see that these forms of discrimination have endured and have disproportionately meant that that third of voters have faced higher barriers to the ballot. Before the VRA, only slightly more than 30% of voting age people of color in Louisiana were registered to vote, and within 2 years of the VRA's passage, registration rates jumped to nearly 60%. So that's the type of immediate impact that we know the federal VRA was able to achieve. But until the Shelby County ruling in 2013, we also know that Louisiana remained one of only 9 states that was still subject to its entirety to the preclearance regimen of the VRA because of enduring documented patterns of discrimination against Black voters. And then for decades, encompassing these years since the passage of the VRA, we know that Louisiana has passed political maps that failed preclearance scrutiny or otherwise did not reflect the needs and demographics of the state. Louisiana, in the years since Shelby, has continued in its saga of redistricting and an enduring fight for fair maps. We know that after the last census, it took Black voters, organizations like Power Coalition for Equity and Justice, the NAACP, filing federal litigation by LDF, ACLU, and our other co-counsel, to challenge yet another discriminatory congressional map. And we also have parallel litigation that's challenging the state legislative maps, all because, as in the decades past, they did not reflect fair representation for Black voters. However, after years of that litigation, the legislature was finally compelled to pass a fair congressional map. And it was once the legislature did that, that swiftly after a group of non-African American voters challenged that now fair representative map with 2 congressional districts where Black voters had a fair shot to elect their candidate of choice. They challenged that district, saying that somehow a remedy to a Voting Rights Act violation could not and should not in itself contemplate race in crafting a fair map, because doing so would somehow violate the Equal Protection Clause of the Constitution, the 14th Amendment specifically. So we're in this land of limbo where Louisiana v. Calais, that challenge against the state by non-Black voters, remains pending at the Supreme Court. It's been argued twice now. The state of Louisiana initially defended the map, which lawmakers passed, knowing the writing was on the wall if they refused to pass a map that fairly represented Black voters. But then the state did 180 and pivoted when the case was set for re-argument and is now trying to chip away at Voting Rights Act protections and undermine them, leaving Black voters and Black-led organizations like Power Coalition as the last line of defense as interveners in that litigation, pardon me. So it's all to say, Louisiana v. Calais is pending. We are waiting for decisions every day, but it's part of this through line narrative of all of these protections within the Voting Rights Act being under Supreme Court scrutiny and being chipped away at, whether in pieces or in just raising the bar for how difficult it is for litigants to be able to bring their challenges and for Black voters to achieve fairness. Ultimately, in Louisiana and beyond, the promise of the VRA and the multi-ethnic, multiracial democracy was designed to protect is under sustained attack with predictable results. In Louisiana, we have also seen parishes close polling places disproportionately in Black communities, and voter turnout in Black communities consistently trail behind their white counterparts. Legislation like the Louisiana Voting Rights Act is a powerful, practical, and popular response to all of these different forms of suppression and dilution, and the legislature cannot sit by while these harms persist and our democracy is hollowed. The Louisiana Voting Rights Act would establish meaningful safeguards we've reviewed here today, like stopping voter suppression and discriminatory practices before harm spreads, before people lose their votes, preventing unfair and racially diluted voting maps at parish and local levels, and allowing communities to defend their rights in Louisiana courts without waiting for years for federal action. So the time is now to pass the Louisiana Voting Rights Act because the right to vote is fundamental, representation is not a privilege, and a democracy without equal access to the ballot is a democracy in name only. So let's pause here for any questions. I know we're right past the hour, but we are available. We also want to encourage each of you to start drafting that personalized testimony, to have it ready to submit to the Committee on Senate and Governmental Affairs, to have it ready to submit to your lawmakers, and to also sign on to the materials that Power Coalition has created, or get ready to raise your voice at the Capitol in the weeks ahead. So I'll pitch it back to Max and be available also for any questions folks might have.
Tori, Imani, thank you. That was so great. I just wanted to uplift one question that we got in the Q&A.
Great.
The question was, when speaking to the committee, is it possible or permissible to bring notes or written marks to the podium for reference?
Absolutely.
Yeah, and absolutely, and I think it's a best practice. But go ahead, Tori. I'll throw it back to you.
Yeah, absolutely. You can definitely bring notes if you're more comfortable reading something that you fully prepared. You certainly can. If you want to have just an outline and make sure you know kind of the three bullets of things that are most important to you to communicate, you're able to bring those. You can also, like, people have brought tablets or laptops or other things. I will warn you that the service is not always the best. So having something written when you're in those committee rooms that are sometimes in basements or in that Capitol can be helpful. But whatever it is that'll make you most confident, whether that's getting up there and speaking more fluidly from the heart, I would encourage you to be prepared to know what you're going to say. But if that is something that you want to have fully written out, outlined, or just more off the cuff, though intentional and practice to an extent before, any of those things are an option. And you can certainly submit both written testimony and oral testimony if you've got different things to say. The dimension that is helpful with providing oral testimony as well is typically those comments are offered after the bill has been presented, after lawmakers have had some debate in committee. So it gives you some more flexibility to respond to what you've been hearing, to react to what kinds of values it's connoting, or what kinds of differences in opinion you might have with people who are not indicating support on the committee, and try to persuade or respond to the issues or flags that they have presented. So oral testimony provides a little bit of fluidity there, though written testimony is incredibly compelling and lets you have a little bit more preparation to know with certainty that your story will be in and will be heard. And of course, you can contribute in more ways than one. You could submit written testimony to committee, or you could send that specifically to your lawmaker, pass them a note when they're on the floor. I know folks will have opportunities to do that on Wednesday, hopefully. Or again, show up to these committee meetings and submit your comments There's a range of different ways to participate, but we hope that these types of talking points, this training helps you in preparing that and also helps you be ambassadors for the Louisiana Voting Rights Act in your community to not just be sharing your story, but encouraging people who you think also should be contributing their voice to this effort to also feel empowered to do so.
All right. Anyone else? Anyone else have any questions or any other things they'd like to lift up? Looks like we have another one in the chat. Will there be transportation to the Capitol available? Yes, I will take that one. If you haven't heard about transportation yet, please write me an email. I'm going to drop my email in the chat right here. Um, and we can make sure we get you the proper information for wherever you are. So I'm going to drop my email in the chat right now. And yeah, please follow up with me on that piece. Okay. Any other questions? Tori, I'll throw it back to you to close this out.
Great. Well, thank you, Max. Thank you, everyone, for taking the time this evening and for being part of this broader movement. I will leave you with the words of one of my heroes, I'm sure one of yours, the late great Rep. John Lewis. Never be afraid to make some noise and get in good trouble, necessary trouble. That is the energy that brought us the Voting Rights Act that he and so many others marched for, put their bodies on the line for in Selma, and who we have benefited from their leadership for these last decades. We want to carry on their legacy. We want to get in some good trouble together. So if LDF or Power Coalition can be a support to you in any of this, please reach out, let us know, and we look forward to seeing you at the Capitol this Wednesday, and for future opportunities to lend our voice to this broader movement for voting rights. Thank you all so much.
Thank you, everyone. See you on Wednesday.